after someone has died, it's very stressful. You're dealing with a lot of emotions. And then you have the big task, or the executors have the big task of administering the estate.
Welcome back to the Steadyhand Coffee Break video series. Now, Ben Franklin has famously said, quote, "In this world, nothing is certain except death and taxes." Well, today's video is not about taxes, but I do encourage you to watch our other video that dealt with the top tax tips for Canadians, which we'll link to in the video notes below. Today's video is, however, about death. Specifically, it's about one of the biggest acts of love and kindness that you can provide to your family when you die. It's about creating a legacy binder or a death binder. Now, rather than creating a scavenger hunt for what to do when you die, a death binder provides direction. A death or legacy binder is a helpful tool that will steer your loved ones in the right direction as it relates to both managing your affairs, fulfilling your wishes, and basically minimizing stress all around. Now, we're lucky today to help us walk through the thinking behind and the preparation of our death binder to welcome back Lucy Main, who leads the estate practice for WeirFoulds here in Toronto. Lucy, thank you for joining us today.
It's my pleasure to be here.
Now, today we are talking about the inevitable. It's not a great conversation per se, but it's something that's super important. And I know you're involved with this conversation with many of your clients. So let's dig in. What is a death binder and why is it important for estate planning?
So I think you've hit the nail on the head, David. The idea being, after someone has died, it's very stressful. You're dealing with a lot of emotions. And then you have the big task, or the executors have the big task of administering the estate. And at least in Ontario and many other provinces, we don't have a registry of wills or powers of attorney, let alone a registry of assets. And so if someone's stepping into the role, they may not know what bank accounts you have, insurance policies, particularly ones that are fully paid up. And so they're really at a loss of where to start. And there's only so much others can do without that information.
We know that you're supposed to have a will, and we know tragically too many Canadians don't have a will. And I know we should spend a lot more time talking about that. But how does the death or legacy binder differ from a traditional will?
So the will is the legal document that the executors are given the power to administer the estate and distribute the assets to the charities or people that you've named. The death binder, or even more broadly an incapacity binder, because it can be useful in that context too, is the tool for the executors or the attorneys for property to do their job. And so it will have hopefully all the information they do need so they can carry out what you have put in the will or the power of attorney.
And I'm 65. I hope to live for at least another 40 years. Haha. When should I be putting my legacy or death binder together?
So I think whenever you're doing your will or your powers of attorney, that's a logical time. A lot of the time you're already gathering all that information for the lawyer who's helping you. So you've kind of done a lot of the job already. And then you come out of that with your will and your powers of attorney. So that would be a logical time. But really, even before you have that meeting with the lawyer, or if that's a bit too much of a hurdle to get to that point, you can start it now. Anything can be done now, and you don't have to wait until that point.
Well, certainly people my age whose parents have either already died or are aging, we see the necessity of really getting our act together on this important issue now. And I was motivated last summer to actually get started. And I call this my death. I call it the book, but I really have incorporated this for my family, whether it's my spouse or my kids, in the event that both my wife and I go together, as a way to help them, avoid that scavenger hunt. So what are the essential documents that I and everybody else should be putting into our legacy binder?
So obvious ones would be the will and powers of attorney for both property and care. So those legal documents. Often people do letters of wishes, particularly about healthcare. So some people call that a living will or advanced care directive, but you may have wishes for your attorneys for personal care to follow when you might want to move into a home or not, when artificial means to keep you alive, that sort of thing. So any of those kind of letters would be useful. Often people have a term in their will where they say, I distribute my personal effects, household goods, in a certain way. And it might not be a legally binding letter, but the will refers to it. And so you would want to keep that in there and any updates. Not uncommon for people to have what's called a hodgepodge ledger. So if you have given different amounts to your children and your will refers to equalizing that through a hodgepodge, we have to find that ledger. And so that would be a very logical place to keep it. If you are a shareholder or a partner in a business, having those agreements in place, because not only in place, but in the binder, because they often speak to what happens to your interest in the company or the partnership on incapacity or death. If there's a marriage contract or cohabitation agreement, those are critical to have in the binder as well. Promissory note. So if you've lent money to the children and you've secured that with a note or to a family member, that note is critically important. And so that would be a good place to have it. Trusts, if you have a family trust in place, or maybe you're the beneficiary of a testamentary trust, so the will of the person who has died where you're benefiting, those documents are important because a lot of these are not registered anywhere. So keeping them in one place would be helpful. And then certain documents relating to assets. So if you have a timeshare, that would be helpful to have that agreement, those sorts of things. And then in terms of, so those are the hard documents that would be useful. Any information about your advisors. So who should they turn to? Accountant, lawyer, that could be your personal estate lawyer, but also your corporate lawyer if you have a business and where the minute books might be kept. Financial advisors, investment advisors, a private banker if you use one, insurance broker, and just providing their up-to-date information. It's stapling their business card to it or typing it out. Email, phone number. You don't have to necessarily have all the information there, but that would be helpful. And then I think it can be useful to have a wish of who to alert on death. So family members, friends, neighbors. So much of this is now done by email and text. No one really has phone numbers memorized anymore. And so it can be hard to, find that cousin in Germany or, the housekeeper that's been helping. Like no one actually knows her email address. So having that sort of thing listed could be really helpful too.
A fair point. So I would just tell my kids to put a LinkedIn notice that I'm no longer around.
Yeah, there you go. All that is very helpful. And when I talk about the hard documents, you don't necessarily have to have all those printed and put in, but that can be helpful, but also where the originals are. So for wills and powers of attorney, originals are critical, even in this world of DocuSign and everything being saved digitally. So indicating, they're in the safe at the bank, or they are lodged with this lawyer or this law firm, because having the copy is not necessarily enough in all instances.
I would add to the people that you need to contact, obviously the executors, because they're the sort of the first people you'd want to reach out to. So, and that's going to be in the will, but it would be a nice. Perhaps the kids don't have access to the will, or whoever has found me.
Yeah, or there's often an independent or professional name there that the children might not know, or an old friend. They might not have their current information.
I don't know if you mentioned any debts that I might have.
So listing of assets for sure, listing of assets and listing of liabilities, and you don't necessarily have to write the amount. And we can talk about what kind of details you put into these things, but the type of asset, the location, particularly if it's not in Canada, and who to contact. So you don't need to update the bank balance all the time, but say I've got a bank account at Scotia, I've got a RIF at TD, and just where they are and the contact information and ideally account numbers would be definitely helpful.
Do you have a publicly available document that we could include in this video for viewers?
No, but that's a good idea. That's a good idea.
Nudge, nudge. If we could create that list as a way to prompt people to view this as an opportunity rather than a challenge, that might be helpful. And the other, as I went through my own affairs, I realized I'm old enough to have a defined benefit pension from one of my original employers when I was in my 20s. Now it's totally de minimis, but it's there, and I know there's some survivor benefits. So I'd want everybody to know about that. So, and the other thing is, you sort of touched on the concept of wishes. I think my wife understands what I want to have happen or not happen to me after I've died. But is that also something that we would put into our legacy binder?
Yeah, I think so. So wishes about your care. So if you're incapable, what you want to have done or not done, and then on death, at least in Ontario, organ donation and funeral instructions are not legally binding. They are often put in wills, but to your earlier point, might not be looking at that right away when those decisions have to be made. So communicating that, and I think it also, aside from them knowing about it, gives them an opportunity to ask questions. So what did you exactly mean by that? Or you say you don't want a lot of money spent on the funeral. Like, what are you thinking there? You do or don't want a religious ceremony, that sort of thing. It can be helpful to talk it out. And so that could be useful too.
Great. Now, have you hit upon digital assets?
No. So we can talk about digital or non-legal assets that we should, or non-legal documents. So digital assets, it's critically important to have some information on that. In most instances, people have ticked a box when they've signed up for an app or an account where they've indicated they won't share the password. But without a password, it can be very difficult to access. And in some cases, a court order is needed. And in many cases, we're not dealing with Canadian law. The server is not necessarily in Canada, so or in the province that you're dealing with. So the most important is listing the digital assets. So I refer to that as anything you can't see and touch. So that's email, access to online banking, your iPad, your Apple ID, any pictures or videos you have in the cloud floating around. Often for most of us, there's no financial value to those things, but there can be sentimental value. It's not uncommon for us to get calls from people that say, I want to just access the iPad for pictures for the funeral. But if they don't have the Apple ID, you're not going to get a court order in that time period, let alone do you really want to incur the expense to do that. So that can be relevant. And also we want to avoid identity theft, which is a big issue. So generally we want those accounts closed if someone's incapable or has died. And so giving them a sense of what assets you have and what you want done with them is really important.
In our family, my wife and I use LastPass. So we really, together, we just need to know one master password to be able to crack open the vault. But I realize now my kids don't know what that password is. So if we go together, yeah. Okay, that's great. So just speaking of sort of security, where should this death binder be stored? Is it better to have a physical copy or a digital copy or both? Do you keep them for your clients?
I don't generally keep a full copy. I do sometimes have certain details. Some of that we get through the process of doing the estate planning. I like to know who the accountant is, the insurance advisor, that sort of thing. So sometimes I already have that, but I do have some clients that don't have a safe place to keep certain information or vault, like security deposit keys, that sort of thing. So we do sometimes retain some of those. Not all lawyers have the facilities to do that. I think the big decision in the first instance is it a physical binder or a digital one? The big issue with digital is access to it, to your earlier point, like if no one has the password to your laptop or however you've saved it, it's not really providing great value. But of course, if it's physical, we have to be worried about access to it, and not only access while you're alive and well, but if you do become incapable, who else might be in the home where that could be found? So it's a real thing to sort of think about. And as I mentioned, you don't have to have all details in there. You don't have to say I have, $5,000 in this bank account and $1 million offshore, whatever it is that you don't necessarily want people to know. But what sort of assets, not necessarily the value, or maybe not the whole account number. You just put the last 3 digits and the bank and what type of asset. So it leads people there, but doesn't necessarily give them all the information. That's important. If it's in a bank safety deposit box, the bank will often require a power of attorney if you're still alive to access, or probate. Probate in many provinces can take a long time to obtain, so it kind of defeats the purpose. So just being thoughtful about where you put it and who has access to it. And then copies, I would generally say one copy, because if you start to create multiples as you update them, you got to remember who you gave copies to, where they are, and update all those copies. So generally one master binder is the right way to go.
And I suspect that the time frame for updating your legacy binder is when you update your will, or if there's some substantive issue involving either your personal finances or your marital status or that kind of stuff.
Yeah, that's right. So those are definitely obvious times. A lot of people will sort of set a time once a year, sort of look at the wills. Does anything need to be updated? And do I need to update anything in this? Have I opened up a new account? Did I move my RIFs to this new institution? Obviously, it'd be good to do that as you go, but that can be hard to always remember to do. So sort of setting aside one time of year where that's what you do, and just check that it's relatively up to date.
Can we make this real for a moment? Can you dive into your experience working with Canadians and give an example or two of how having a legacy binder and not having a legacy binder has contributed to, the success of the estate settlement or the lack of success?
So in Ontario, probate can take many months to obtain, and that's from when you apply. And a lot of the work or delay is also caused because we need to have a full listing of assets before we apply for probate. And so if we don't have a good starting point, it is very difficult. And it used to be that you'd check the mail, and as you got statements once a month, you'd have all those for the deceased person. But now a lot of those are e-statements, and we might not have access to their email account. And so having as much estate asset information up front, the better. There are ways where you can update the probate application, but there are legal fees associated with that. So it is much better to go into it from the beginning. The other issue we often find are assets discovered later, which sounds like a great thing when you find another bank account, another investment, but you may have closed the estate account. You may have it could be many years later, and now you have to go find the beneficiaries and their updated information and file another tax return and some court documents. So there are costs and pain associated with that. And sometimes, it's a $10,000 account. It's going to cost you $7,000 to do all that, right? And the pain. So I find that a big issue. And then sometimes there could be many assets that just never go realized, that they're just sitting out there, and money is lost and just sits out there for a long time.
And that money goes to the public guardian?
So I think it depends. If it's never discovered, we never know. And at some point, someone might realize there's an asset. Bank accounts go dormant after a certain period of time and sort of just sit there. So it doesn't necessarily go to different people. It just sits there. We've had to administer estates where 40 years later, it's realized, they never transferred the house. Like if someone stayed in the house and was never transferred, and you have to go back and find. And it still goes to that person, but we've now got to deal with death certificates and find that will. And in some cases, we've had to probate wills from the 60s because it was never done. And it's always more expensive to have to do it that way.
Wow, that's extraordinary. It just behooves the fact that we really do need to get our act together. We need to make sure that we've been thoughtful about putting our will in place, and that we've been thoughtful about putting our legacy binder in place, and that we've made this far less of a scavenger hunt and far more of an efficient, if not, it's never going to be a fun exercise for sure, but it just can't be an onerous exercise for those of us that, for those of us that have to either do it or that have loved ones that have to do it on our behalf. And we've talked about a whole bunch of other things. Lucy, one of the things that is cause for some consideration is where to actually locate your legacy binder. And you've got different options, I guess. You could locate it digitally in the cloud. You could have a physical binder like I do. What to do with that physical binder? Do you give it to your executors? Do you keep it in your home somewhere? Do you put it in a safety deposit box? Can you just talk about some of the best practices around that?
Sure. So deciding between digital and physical, I think, is the first decision. If it's digital, we have to think about accessing it. Who will have the password to get on your computer or whatever app you use to save that information? and then making sure you're comfortable with the privacy and security behind wherever you're storing that information. And then if you're having a physical binder, I often advise clients to have one copy, so we're not worried about multiple copies and when they're updated and if they're all updated at the same time, and keeping it at home. You could put it in a safety deposit box if it's large enough to do that. Are you likely to go update it as frequently as if it were at home? Might be an issue. Also accessing it. So at least in Ontario, with a lot of financial institutions that do have safety deposit boxes, you need the power of attorney if the person is still alive, but you need access to it, or a probated will in order to remove the binder. And that could sort of defeat the purpose behind it. And so maybe keeping a copy at home so that you're able to update it regularly and it's secure at home. And then making sure the people who need to know about it know that you have a binder and where it's located. So your executors, family members that would be more likely to be involved, know that you have it in the top drawer of your desk, in the filing cabinet, in the basement, wherever you might keep it.
How about a two-staged process where I have a letter that then tells my beneficiaries where to go, which would, to me, it makes sense to go to my estate lawyer, like to you. Is that a service that you offer clients?
Yes, I would say one of the first calls is after someone's died is they call the estate lawyer. There could be funeral instructions in the will, so that's often what we're first looking for, but very common to call us. And what we do is sort of triage. So what do you need to deal with in the first days or weeks after someone has died? We don't need to apply for probate. We don't need to start collecting all that information, but what do we need to do? And some things like dealing with pets and perishable items, like there are certain things that have to be dealt with right away, and then others that can be dealt with later. And we may have information about where that death binder is located, that one has been created. We might have been involved in some of the creation of it. And so that can be helpful. So the lawyer, executors, and perhaps any other advisors like the accountant, perhaps financial advisors might have that information about the binder.
I think that's what I'm going to do. I think I'm going to have a letter sitting in a drawer that everybody knows where it is. And that letter basically just says, here are the first 3 things that you need to do. And in order to get access to, I mean, I'll have all of my sort of personal immediate wishes, but in order to get access to all of my affairs, they're going to have to, through the executors, get in touch with my estate lawyer. And that's where I'm going to hold all of those documents.
I think that's a good idea.
And I'm going to have my estate lawyer reach out to me every year and make sure that it's up to date.
Some will do that.
Lucy, we could spend a lot more time, I'm sure, dealing with this, but let's wrap it up. There's a lot here emotionally, practically. What advice do you have for anybody who might be feeling that this is an overwhelming kind of exercise? And are there any resources that you can point people to help get them started and move them through this exercise?
I'd say anything is better than nothing. So you can start small. You can just have a list. Like I have a bank account here. I have this investment account here. My lawyer that did my will can be found here. And just start with that. Like that is better than nothing. And then over time, you can add to it. You don't have to do it all at once. And you don't have to have this once a year sort of update. These are just sort of ideal things to do, but anything, I can assure you, is better than nothing. So I'd say start there. There are some binders available through Amazon online. I've seen some on Etsy. So if you need help with one that already has the tabs in there or has the boxes to fill out, like that's a help, that might help some people. And there's a few of those available. There's articles that are starting to pop up. If you do a general search, legacy death binder, you'll see more and more articles. And then talking to other people, I find helps. So what are your family members doing? What are your friends doing? And like you've shown what your physical binder looks like. Anyone seeing that now thinks, oh, I can visualize what it looks like and what should be in it. And just hearing what other people are doing can help. And so I'd say those are good starting points.
Well, you've given me some great ideas. My original effort at putting together my book was done in May of 2023. This is November 2024. And I've gone from just listing my lawyer, my executors, people that owe us, what we own, and what debt we might have, to including that extensive list that you laid out. And I've begun checking off on my own list here today. So we will put that list into the notes of the video. And Lucy, I'm sure if people have questions or comments, we'll hear about those in the comments below. We encourage that, and we'll do our best to answer them and address them. Lucy, thank you again for joining us and talking about this, frankly, inevitable part of both life and death.
My pleasure. Thank you for having me.
And thank you all for taking time out to watch the YouTube Steadyhand channel. Feel free to leave any comments, as I mentioned, or if you have any questions, we'll do our best to address them in the comments below. And if you haven't yet had a chance to subscribe to our channel, I encourage you to do so, and you can be notified of any new content that we're putting out there. Thanks again for watching, and bye for now.